want to introduce our co-host from today, Annette Bird, with the Professional Community Association Manager, acronym after her name. She knows her stuff, from CopperDoor Management. Annette, please tell us a little bit about yourself and your company.
Sure. Thanks so much, Jeff. I am a third-year practicing association community manager. I've been both an manager for communities and also a management company executive. And this is a topic that we're really excited to work with Kerstin in the education. It's perhaps one of the most impactful responsibilities a board of directors has in their community, and also one of the most important that a manager has when it comes to compliance. Compliance not for control, but also sometimes for maintenance and for property values. So this is a topic that we're passionate about doing it right. As Jeff mentioned, I am one of the co-founders of CopperDoor Community Services. We are a full service management company. We provide full service to communities in Pasco, Hillsborough, Pinellas, and Manatee counties, and then consulting services to communities across the state. We're very happy to work with Kerstin today on this. Thank you so much, Jeff.
Thank you, and thanks for collaborating with us. So with that said, let us now turn it over to our managing attorney over in the Tampa Bay office. Well, Tampa Bay area office. This is here we go, broken record, our walking encyclopedia, Kerstin Henze. Kerstin, take it away.
Thanks, Jeff. Good morning, everyone. I'm Kerstin Henze, and I'm one of the attorneys for the law firm of K. Bender Rimbaugh. For those of you who are not familiar with the firm, we are an exclusive community association law firm. So that means that we exclusively represent your condominium, your HOAs, and your cooperative associations throughout the state of Florida. We have about 26 attorneys throughout the state, and we also have multiple locations. So our main office is in South Florida in Pompano Beach, but we also have an office in Palm Beach Gardens in the Orlando area. And like Jeff mentioned, I manage the West Coast office for the firm, which is located in Tampa. I have been practicing law for 17 years, going on 18 years, and I've been with the firm since 2010. So I guess you can say I've been doing this practically my entire career.
Since she was 10. Since she was 10.
Right. All right. I'm going to go ahead and share the slides, and then we're going to start. All right. Can you see them?
We do. Yes, there we go. You got it to full screen. And for those of you folks, just real quick, a couple of you typed in the Q&A as their video. You can't see anything. This looks like it's a local setting on your end. At the top of the Zoom interface, you see a webinar tab. You see a Kerstin Henze screen tab. If you hit the Kerstin Henze screen tab, you'll see the slides. If you hit the webinar tab, you'll just see Kerstin. So that's your choice, your option up there. But if you're not seeing anything and you're only hearing us, it is a setting on your end, because only a couple of you have expressed concern about that. So check your audio and video settings locally where you are. Kerstin, back to you.
Okay, let me go a few slides. Not sure what happened there. Okay. All right, so we're going to talk about covenant enforcement. So the first premise is that the association is charged with responsibility. Second. Let me move this to the side a little bit. So the association is charged with the responsibility of uniformly enforcing the governing documents and the covenants, restrictions, and rules and regulations set forth therein. The failure of the association to enforce covenants, restrictions, rules, and regulations in a timely manner may result in a waiver or forfeiture of enforcement rights. Now, directors owe a fiduciary duty to do what they reasonably believe to be in the best interest of the association. Now, let me sort of deconstruct the initial sentence. So, you have an obligation, a fiduciary obligation, to enforce your not only covenants set forth in your governing documents, but also your rules and regulations. Let me backtrack a little bit. Governing documents, for those of you who are new to the board, governing documents consist of three primary documents: your declaration, and it can either be the declaration of condominium if you're in a condominium, or declaration of covenants if you're in an HOA governed under Chapter 720 of the Florida statute. And then the governing documents also include your articles and your bylaws. Now, your use restrictions, the covenants that you're going to be enforcing in your community, they should be set forth in your declaration. There shouldn't be any covenants or restrictions in your articles of incorporation or in your bylaws. So if you do have any use restrictions or covenants there, get with your legal counsel to move those covenants and restrictions to the declaration, which is where they belong. Now, the first thing about enforcing your covenants and rules and regulations is that you want to make sure that your covenants, your restrictions, your rules, they're clear. They're clear, and there's no ambiguity. There's no vagueness. Why? Because if your rule or your covenant is ambiguous or vague, then you're going to face enforceability challenges. So a very common one that I see in governing documents is one where the documents or the rules might say, anyone who permanently resides in the community has to get board approval. Well, if you come to me and ask me to write a demand letter to someone to enforce that rule that says anyone permanently residing has to get board approval, I will ask you the question, well, what does it mean to live in your community permanently? Is it after they've resided there for 30 days, 60 days, a year, right? And so you want to make sure that you have clear rules, clear covenants. If you're ever amending, definitely encourage you to get with your legal counsel to make sure the language is proper. Now, the other thing is, assuming that your rules and covenants are clear, concise, you want to make sure that you uniformly enforce your governing documents and your rules. So uniformly means you enforce them against everybody, all of your residents and your owners, and not just against some. The reason you want to do that is because if you enforce a covenant or rule against some but not all, the next time you enforce the same covenant or rule against these other individuals, they might have a defense that they can raise to your enforcement action. Many of you may have heard of selective enforcement. Okay, well, selective enforcement, it's not a cause of action. Sometimes owners will say to the board, I'm going to sue you for selectively enforcing a covenant against me. Well, selective enforcement, it's not a cause of action that an owner can bring against the association. Rather, it's a defense that is raised when you as a board try to enforce a covenant against them, or may even file a lawsuit against them to enforce a restriction. Okay, they can argue, well, you have enforced this restriction selectively. You've enforced it against, John Smith, but you haven't enforced it against the others. And now you're coming and enforcing it against me, so you're selectively enforcing. And if that defense is properly raised, then the association would lose the lawsuit, the enforcement action. You also want to make sure that you enforce your covenants not only uniformly, but timely. And timely means, generally speaking, within 1 year from the date that the board knew or should have known of the violation, right? So certain violations are pretty open and notorious. For example, if an owner installed a fence and they were not allowed to install a fence, well, if that fence has been, on the lot for at least a year, the board knew or should have known of it, right? Because it's pretty obvious there's a fence. So you want to make sure you take legal action to enforce that covenant, to force the owner to remove that fence timely within the 1 year period. Otherwise, the owner will have a defense that they can raise to your enforcement action. In this case, the defense would be waiver. You've known of the violation, or you knew of the violation, you sat in your hands too long, okay? You didn't take legal action to enforce the restriction against me. Now you've waived the ability to come and enforce the covenant against me, okay? So that's waiver. So you've got waiver, and then you've got selective enforcement defenses that could be brought if you don't uniformly and timely enforce your covenants and your rules and regulations. Now, I've talked about covenants. Let me just quickly mention rules and regulations. Now, your rules and regulations are not part of your governing documents, okay? They're just what they are. They're rules and regulations. Rules typically are either supposed to clarify what's in your governing documents. Okay, so for example, if you have a covenant or restriction in your declaration that says anyone that permanently occupies a unit or a lot must be approved by the board, assuming you have rulemaking authority, you can use your rulemaking power to then adopt a rule to clarify what does it mean to permanently reside in your community. Okay. Now, the thing about enforcing rules and regulations is that in the state of Florida, they have to pass a 3-prong test. Okay. And only if the 3 prongs are passed will the court enforce it. Okay. Typically, when boards adopt rules, 1 or 2 of these things are missing, in which case, if you were to come to me to enforce a rule, I will tell you, well, there's a problem with this rule. So I recommend you either go back and revise the rule or do whatever is necessary to address the rule deficiency, and then we can look to enforcing. But the 3-prong tests include, number 1, you have to have authority to adopt the rule in your governing documents. Typically, that authority is found in either the Articles of Incorporation or the bylaws. Typically, in the power section, you should see a statement that the board has the power or authority to adopt rules and regulations concerning the community, concerning common elements, common areas. And then it should also say that you have the authority to adopt rules concerning the use of the property, the use of the lot, the use of the unit. Okay. Assuming you have that rulemaking authority, the second prong is that the rule, whatever rule you adopt, cannot conflict with your declaration, whether expressly or by implication. And that's the prong that typically boards get in trouble with, right? So, for example, if you have a restriction in your declaration that says no pets allowed, okay, and then you adopt a rule that says, well, actually, pets are allowed, but you can have no more than 2 pets. Or pets are allowed, but they have to be no more than 50 pounds. That's a clear example where the rule conflicts with what's already in the declaration. And when there is a conflict in terms of hierarchy of your documents, the covenants in your declaration will control. So in this case, your rule would be unenforceable. The trickier scenario is when the declaration is silent on a particular issue. Let's say your declaration doesn't address pets. Silence. And then you as a board go ahead and you adopt a rule that says no pets allowed. Okay. Well, under the law, the fact that the declaration is silent on pets, it implies that pets are not prohibited. They're not restricted, which means if you then adopt a rule that expressly says no pets allowed, it conflicts with what's in the declaration. And again, you're going to have an enforcement issue there. And then the third prong is that the rule ultimately has to be reasonable, right? That's more of a question of fact for a judge to ultimately determine whether or not a rule is reasonable. Just keep that in back of your mind. So enforcing rules becomes a little bit trickier. So make sure that, get with legal counsel, have them review your rules and regulations, make sure you have the authority to adopt them, and more importantly, make sure that they don't conflict with the declaration. If they do, it's very possible you may have to amend the declaration to put some rules in there to enforce them in the future. Okay? All right. Let's move on. Okay, so let's look at some of the specific covenants and restrictions that the board might be responsible for enforcing. So you might have architectural standards in place that you have the authority to enforce. Make sure you have written standard specifications for different types of alterations. Okay, so if your documents allow you as a board to approve or disapprove certain alterations, make sure you have standard specifications of what you would approve or what is not allowed, right? If you're allowing, painting the exterior of your home requires board approval or approval of your ARC committee, make sure that you have adopted a color wheel, right, of what colors are allowed in your community. Because if you do not have standards or specifications, it will become substantially more difficult to enforce your standards in the community. Age restriction. You might be in a community that is classified as a housing for older persons. Well, if you are looking to enforce your age restrictions, make sure that you actually are a qualified housing for older persons. Make sure your governing documents contain certain language regarding your qualification. Make sure you're doing your census every 2 years and you have proper documentation. Pet restrictions. You might have restrictions on leasing or sales. You might have guest occupancy restrictions, okay? Parking, vehicle restrictions. And then most documents have nuisance restrictions, right? You can't create a nuisance in your community. A point I want to say about nuisance conduct is that is a very, it's a difficult covenant to enforce. Typically, if you want to pursue a nuisance violation in court, right, and typically will come from occupants or tenants who've just demonstrated an inability to abide by your documents and your rules, and they're just creating havoc in the community. For nuisance, you want to make sure that you properly document every incident of nuisance. And it takes more than just one incident to qualify as a nuisance, right? It's not just that one incident where, the occupant, had a loud party or just, was blasting music at, midnight. It's not that one incident. There has to be repeated incidences of nuisance conduct in order for you to be able to enforce it and either force the owner to stop the nuisance, or perhaps you're looking to, compel the removal of an occupant or a tenant. So you want to document, and documentation may include anything from, written complaints from other residents in the community, internal memos, if you have management, right? Or if you have, concierge service, right? Or rover that, that is called, in the middle of the night when there is a potential issue, and they have internal procedures where they document certain conduct. Okay, that would qualify as documentation. Police reports. If the police ultimately has to be called to the premise, make sure you obtain a copy of the police reports, right? And just put it in the file. All of this, okay, all this backup documentation will eventually be requested by your attorney when they send a demand letter, right? And definitely when you're pursuing the violation in court. Okay, now enforcement action. So you have a violation, and now what? Well, typically your enforcement action will start with some sort of violation letter or a demand letter. So your first step in an enforcement action is to mail the owner notice of the violation. The notice must include a statement of violation and should provide a deadline for compliance, allowing the violator to correct the deficiency. So, if you don't already have some kind of enforcement policy, then, consider adopting one where you outline basically, these are the steps that we're going to take in order to enforce a violation. And it could start with, the board or management sending a first notice of violation to the owner. Okay. You might follow that initial letter maybe with a second notice of violation, or you might go straight to a final notice of violation before you turn the file over to legal counsel for a more formal demand. Okay. But it's important to have a uniform enforcement policy. This way owners are aware these are the steps that the board is going to take in enforcing any type of covenant or rule violation. So if the violator is the owner, we typically recommend sending the letter to, whatever address you have on record, whether it's the unit or lot address, or if there's an alternate address, you'd want to send it to both the unit, lot, and then the alternate address. And you want to send the letter both certified as well as regular mail. If you have an email address for the owner, you can certainly send it to them via email as a courtesy. Now, if the violator is an occupant or a tenant, I would still recommend sending the letter to the owner of the unit, and then you can also send a copy of the letter to the occupant or the tenant, because ultimately the owner is responsible for the conduct of the occupants and tenants of the unit, right? So ultimately the owner is the one that's going to have to address the violation with the tenant or the occupant. Otherwise, the owner, is ultimately responsible and on the hook for it. So if you've already sent your initial violation notices and demand letters, and you've given the violator a reasonable opportunity to comply, and they haven't done that, then typically the next step is to basically forward the file to your legal counsel for more formal action. Okay. Now, when you forward the file to your legal counsel, they're not going to immediately go ahead and file a lawsuit in court, right? Typically, they will have to also send a demand letter, a more formal one, right, on the firm letterhead. And then if the owner doesn't comply or the occupant doesn't comply, then we'll talk about some remedies. Okay. Okay. So you've sent violation notices. Your law firm, your legal counsel may have also sent a violation notice, and there's been no compliance. So now what? Well, you have some enforcement remedies. You have some options. And we'll talk about fining. We'll talk about suspension of use rights, suspension of voting rights, and then we'll talk about ultimately filing a lawsuit. And before you can file certain types of lawsuits, there's also pre-suit mediation or pre-arbitration requirements that you have to fulfill. Now, it is very possible, and you probably already even, thinking in your head, well, fining doesn't work for us, or it's not a viable option, or suspension of use rights. And that's okay, right? These are just some of the options that you can explore in enforcing a violation. But it might not be viable for your community, right? And that's okay. So there are other options. So let's go through this. All right, authority to fine for HOAs. And these are HOAs that are governed under Chapter 720 of the Florida statute. So the association has the authority pursuant to Section 720.305 of the Florida statute to fine an owner or the owner's tenant, guest, or invitee for failure to comply with the governing documents or association rules. The authority to fine does not have to be provided in the governing document. So, especially some of the older documents that may have been recorded, back in the 70s or the 80s, even the 90s, they might not expressly say that the board can fine. And that's okay. The statute gives the association the authority to fine. Okay. Now, a fine under the statute cannot exceed $1,000 per violation. So it can be less. It just can't be more than 100, and may be levied on the basis of each day of continuing violation, but may not exceed 1,000 per violation in the aggregate unless otherwise provided in the governing documents. So that means that, for example, let's say you have a no pet community and you've noticed that an owner has been walking a dog, and you send them a letter saying, hey, it's come to our attention, you have a dog, please remove the dog by this date, or you'll be subject to either fine or other legal remedies. Each day that pet remains in the home, right, you can levy a fine up to a maximum of 1,000 for that particular pet violation, unless, of course, your documents provide something else. So in HOAs, for HOA, if you're subject to 720, you can have your declaration allow the board to fine for more than $1,000 in the aggregate. Now, that means that if your documents are clearly address fining, okay, or has a cap at 1,000, you can amend to allow you to impose a fine in excess of 1,000. Now, typically amendments to declarations do require membership approval, so be aware of that. But if you can get members to vote on that, then this could be a viable remedy for you. Not sure why this slide's a little cut off. Now, the statute, Chapter 720, also says that a fine of $1,000 or more may become a lien against the parcel. Okay, so fines of less than $1,000 cannot be liened by an HOA, which means that if your documents allow you to fine for $1,000 or more, okay, and gives you the authority to lien, to adopt those fines as a special assessment and then collect it through the lien foreclosure process, then you can do so. Okay, so in the HOA setting, fining becomes way more of a viable option, especially if you have the ability to lien in your governing documents. Now, the thing about fining is that you cannot levy a fine unless the association has first provided the violator with notice, written notice of the violation, and an opportunity to appear at a hearing no sooner than 14 days from the date of the notice, right? So with fining, remember, it's a two-step process. The first part is that the board adopts the fine at a duly noticed meeting, but that fine cannot be imposed until you've provided the violator with the written notice of the hearing at which they're entitled to attend to contest the fine. And that hearing cannot take place sooner than 14 days from the date that you send the notice. Okay. Now, if the hearing, Chapter 720 was revised 2 or 3 years ago, which now says that the hearing, that committee hearing, must be held within 90 days after issuance of the notice. Okay, so it's not, any date. You have now more of a time crunch within which to hold that meeting. Now, the hearing has to be held before a committee of at least 3 members, association members appointed by the board, who are not officers, they're not directors, or employees of the association, or the spouse, parent, child, sibling of the officer, director, or employee. Okay, so completely independent from officers, directors, and employees. So yes, I recognize that for some communities, especially some of the smaller communities, getting a neutral, third party who's not somehow affiliated with an officer or director or an employee of the association might be difficult. And like I said, that's okay. This might just not be a viable option for you. Now, it is the committee's role to either affirm the fine or reject the fine. The role of the committee is not to negotiate the amount of the fine. It is simply a yes or no vote. Okay, and if the committee does not approve the fine or the suspension, which we'll talk about momentarily, then it cannot be imposed. And then within 7 days after the hearing, the committee must provide written notice to the owner at his or her designated mailing or email address that's in the association's official records of the committee's findings, which includes any applicable fines or suspensions that the committee approved or rejected, as well as you have to let them know how the violation may be cured. Okay, that's if the violation is something that can be cured and hasn't been done that. Okay. You must also include on that letter the date at which the fine must be paid. Oops. Okay. Now, if the violation has not been cured, and by the way, these are changes to Chapter 720 of the Florida statute that went into effect 2 or 3 years ago. So the statute now provides that if a violation has not been cured before the hearing or in the manner specified in that 14-day written notice or the committee's finding notice, then a fine may not be imposed. If a violation is not cured and the proposed fine levied by the board is approved by the committee by a majority vote, the committee must set a date by which the fine must be paid, and that date must be at least 30 days after delivery of the committee's findings notice. Now, attorney's fees and costs may not be awarded against the parcel owner based on actions taken by the board before the date set for the fine to be paid. So can seek attorney's fees before that time frame. If the violation and the proposed fine levied by the board is approved by the committee, and the violation is not cured or the fine is not paid per the committee's finding notice, then reasonable attorney's fees and costs may be awarded to the association. However, attorney's fees and costs may not begin to accrue until after the date noticed for the payment in the committee finding notice and the time for an appeal has expired. Okay. Now, Chapter 720 of the Florida statute was also modified 2 to 3 years ago to provide the following. So notwithstanding anything to the contrary that's provided in your governing documents, the association may not levy a fine or impose a suspension for any of the following. So for leaving your garbage receptacles at the curb or end of the driveway within 24 hours before or after the designated garbage pickup day, or for leaving holiday decorations or lights on your structure or other improvement on the parcel longer than the time frame indicated in the governing documents, unless such decorations or lights are left up for longer than 1 week after the association provides written notice of the violation to the parcel owner. Okay. Let's move on to authority to fine for condominiums. So for condominiums, association also has the authority to fine pursuant to section 718-303 of the Florida statute. The authority to fine does not have to be set forth in the governing documents, like I mentioned with HOAs. You have the same fining process and dollar limitations for condominiums, as I mentioned for HOAs, right? So fine cannot exceed $100 per violation or $1,000 in the aggregate, right? And the process is also the same, two-step process, right? The board adopts the fine, but then you still have to give the violator an opportunity to go before that committee with 14-day notice of that committee hearing date. Now, the distinction is that for condominiums, a fine may not become a lien against the unit. So remember with HOAs, if their declaration gives HOAs the authority to collect a fine of $1,000 or dollars or more, if you have the authority to collect it as a lien, you can. For condominiums, the statute says you cannot recover a fine through the lien, which means you cannot amend your declaration to give you the authority because the statute already says you cannot. Okay, so yes, there's a little bit less of teeth in the condominium setting than in the HOA setting. However, if the fine is not paid, the statute does say that it may be used for suspension of use rights. Okay. Now, if the proposed fine or suspension that we'll talk about in a few slides is approved by the committee, the fine payment is due 5 days after notice of the approved fine. And the association must provide written notice of the fine or suspension by mail or hand delivery to the unit owner and, if applicable, to any tenant, licensee, or invitee of the unit. Okay. Now, suspension of use rights and voting rights. For both HOAs and condominiums, you can suspend the rights of an owner, an occupant, or tenant to use portions of the common areas, elements, common facilities, or any other association property, as well as suspend the owner's voting rights if the owner is more than 90 days delinquent on any monetary obligation due to the association. So you can suspend use rights for delinquencies that are more than 90 days. Okay, and monetary obligation in this case refers to not only your regular assessments, it can include special assessments, attorney's fees, costs incurred in collection efforts, as well as a fine, right? So if you've imposed a fine and the fine hasn't been paid, well, that's a monetary obligation owed to the association. If they're more than 90 days delinquent on paying that fine, you can move on and suspend use rights. Now, if you are suspending use rights or voting rights based on delinquency, the suspension must be approved by the board at a duly noticed board meeting, but you don't need a committee hearing. That's only if you're suspending use rights for delinquency. Okay. Now, suspensions, they do not apply to portions of the common areas or common elements used to provide access to the parcel. You cannot suspend use rights to utility services. You also cannot impair vehicular or pedestrian egress to and egress from the parcel, including the right to park. Okay. Suspensions also cannot include limited common elements intended to be used only by that unit. So, for example, if the balcony is a limited common element, you can't suspend use rights, the owner's rights to use their balcony. Also cannot suspend use rights to common elements needed to access the unit, to utility services, parking spaces, or elevators. So really, the suspension of use rights really applies mostly to your common amenities, right? Your pool, your gym, your clubhouse, typically facilities that you can control access to. So if you have a fob system, right, that you can, deactivate, then this probably, is a viable option for you. If you don't have that mechanism to control access to these facilities, then maybe this is not a viable option for you. Now, effective 2017, Chapter 718 says that you can only suspend use rights and voting rights if the monetary obligation is at least $1,000, and you have to provide at least 30 days notice to suspend the voting rights. So not only does the owner have to be delinquent more than 90 days, the amount of delinquency has to be at least 1,000, and you have to give them at least 30 days notice of the delinquency before you suspend their voting rights. And then new legislation that went into effect 2 or 3 years ago also now provides that at least 90 days before an election, the association must notify unit owner or member that his or her voting rights may be suspended due to non-payment of a fee or other monetary obligation. Okay. So for suspension of use rights and voting rights to take effect, written notice of the suspension must be mailed or hand-delivered to the parcel owner, and then if applicable to the occupant, licensee, or invitee of the parcel or unit. And then if voting rights are suspended, the voting interest allocated to the parcel or unit is not counted towards the total number of voting interests for any purpose, including the number necessary to establish a quorum. So what that means is if you've suspended the voting rights, let's say you have a community of 100 units or parcels, and you've suspended the voting rights of 10 owners. And let's say that quorum for your community is 30% of the 100. If you've suspended the voting rights of 10 owners, then quorum is going to be based of 90, not of 100. And let's say you're presenting amendments to the owners for approval, and it requires a vote of the majority of all the owners. And if you've suspended voting rights for at least 10 owners, that means you need to get a vote of a majority of the 90, not a majority of 100. Okay, so that's how suspension of voting rights works. Okay. Now, you can also suspend use rights for covenant and rule violations. The association may suspend for a reasonable period of time the right of an owner or their occupant tenant to use common areas, facilities, or any other association property for failure to comply with any covenant or association rules. You cannot suspend use of portions of the common areas used to provide access to your parcel or utility services, right? Or impair vehicular pedestrian egress to or egress from the parcel, as well as the right to park, right? So again, this is really suspension of use rights to your common facilities. A suspension for failure to comply with the governing documents cannot be imposed, of course, unless the violating party has had an opportunity to appear before the committee on the issue. The same procedure is a fine. So unlike suspension of use rights for delinquency, which only requires a board vote, suspension of use rights for covenant violation or rule violations requires that two-step process. Adoption by the board first, and then a committee hearing with 14-day notice. Okay. So those are your fining and suspension of use right remedies. You can try those in addition to pursuing further legal action, or if those are not viable options for you, then you may have to consider these other options that I'm going to talk about next. So before you pursue a covenant violation in court, there's certain types of disputes that have to go through pre-suit mediation process, okay, for HOAs under 720. And in this slide, we've outlined the types of disputes that will be subject to pre-suit mediation. So they include, for example, use of or changes to the parcel or the common areas, amendments to association documents, meetings of the board and committees appointed by the board, membership meetings, not including elections, access to official records, and then covenant enforcement. So for purposes of covenant enforcement, right, most of your covenant violations will require pre-suit mediation. These other points here, if an owner was to challenge certain actions of the board, for example, not properly holding board meetings or membership meetings, or if they have, some kind of challenge they want to raise to access to your official records, they would have to also go through pre-suit mediation. So initiate the mediation process before they can file legal action against the association on these issues, okay? Now, disputes that are not subject to pre-suit mediation for HOAs include collection of an assessment, fine, or other financial obligation, including attorney's fees and costs. This is why if you are pursuing collection action against a delinquent owner, the association doesn't have to go through pre-suit mediation. You typically, you follow the statutory process for recording a lien and then filing a foreclosure. Any action to enforce a prior mediation settlement agreement between the parties, eviction or removal of tenant or occupant from a parcel. So this will come into play if, we talked about nuisance earlier on. Let's say you have an occupant that is a nuisance and you have documented the nuisance over time, right? And you have sent demand letters and the owner just hasn't removed the occupant. Well, under the statute, if the cause of action, if what you're looking to pursue is remove the occupant from the property, right, then you can pursue, you can file a lawsuit in court without having to go through pre-suit mediation. Similarly, if you're looking to remove a tenant from the property, whether it's because they're a nuisance or they've, violated other covenants, you wouldn't have to go through pre-suit mediation. Okay, so you'd file a cause of action in court and then pursue the legal action. Now, alleged breaches of fiduciary duty by one or more directors, So if any owner has a potential claim against the board for breach of fiduciary duty, they also don't have to go through pre-suit mediation. They can go and file the lawsuit right away. Recall and election disputes are also not subject to pre-suit mediation. And then disputes between and among parcel owners or between parcel owners and tenants, unless, of course, the association is a party. Now, condominium dispute. Also, the condominium statute used to have a requirement to pursue a pre-suit arbitration, okay, before the association or an owner can file legal action in court. That pre-suit arbitration process is no longer mandated. So you can still pursue our arbitration, but you also now have the option to pursue pre-suit mediation instead of pre-suit arbitration. Okay. Now, the disputes that are subject to pre-suit mediation / arbitration include the authority of the board under the law or the governing documents to require an owner to take an action or to refrain from taking an action involving the owner's unit. So if the board is looking to force the owner to do something, or the board is looking to compel the owner to stop doing something they're doing, right? That would be subject to pre-suit mediation arbitration. Disputes concerning alterations or addition to the common elements, as well as disputes involving the failure of the board when required by law or governing documents to either properly conduct elections, give adequate notice of meetings, properly conduct meeting, or allow inspection of books and records. Okay, these are all subject to pre-suit mediation arbitration for condominiums. Disputes that are not subject to pre-suit mediation include issues concerning title to a unit. So typically this could come up if you're one of those associations that has the ability to approve or disapprove a sale, and an owner took title to a unit without going through the approval process. And, you know, based on the background check, the board would probably not have approved the individual and now is looking to void title or invalidate title. Then if you're looking to pursue that cause of action, you wouldn't have to go through pre-suit mediation arbitration. Also, collections or levying of assessments, eviction or removal of tenant or occupants, similarly to HOAs, alleged breaches of fiduciary duty by one or more directors, or claims for damages to a unit based on alleged failure of the association to maintain common elements or condominium property. So if an owner has a claim against the condominium association for, failure to maintain common elements, and as a result of that, they sustain damage to their unit, then they could technically sue the association without having to go through pre-suit mediation. All right, we're almost at the end. Additional disputes that are not subject to pre-suit mediation in condominiums involve recall and election disputes, as well as disputes between and among parcel or unit owners or between unit owners and tenants, unless, of course, the association's involved. Now, 2 or 3 years ago, the statute was also revised to include the following. So effective July 1st of 2027, the term dispute will also now include failure to obtain the milestone inspection, failure to obtain structural integrity reserve study, failure to fund reserves, and then failure to make or provide necessary maintenance or repairs to the condominium property recommended by the milestone inspection or your CEUs study. These disputes, however, are not subject to mandatory non-binding arbitration. Rather, they have to be submitted to pre-suit mediation. And then if they're unresolved, then they can be pursued through litigation. But that's effective July 1st of 2027. Okay, and then the last two slides, I've basically outlined a very general general process of how both mediation and arbitration are initiated and pursued. These, obviously more for your legal counsel to know, but just so you have an idea, with pre-suit mediation, essentially it starts with sending a certified letter to the violator. The letter has to include 5 mediators, and then you have to provide 20 days to respond, also via certified mail, agreeing to mediate with one of these 5 mediators. Okay. And then if the owner agrees, the parties have to mediate within 90 days, and the parties share the mediator's fee equally. Okay. So mediation, for those of you who are not familiar, is a process by which basically, both parties gather in a room with this third party, neutral party called the mediator. And the goal of the mediator is essentially to have these two parties come to an agreement. Okay, so that's what mediation is. So both parties at mediation will share the cost of the mediator. Okay. And then let's just quickly, if there's an impasse, meaning if the parties end up not agreeing at mediation, then essentially, the association can then pursue the lawsuit. Now, in arbitration is a little bit different than mediation. With arbitration, you've got this third party called an arbitrator, and that individual basically acts like a judge. So arbitration is more of almost like a mini trial, less formal than a trial, but ultimately the arbitrator is the one that will make a decision in the case. And it really just starts with filing a petition. Typically, owners are the ones that will file a petition in with the division. There's a filing fee. An arbitrator is appointed to the case. And then essentially you'll end up having a mini hearing on the matter. Okay. And then the party who prevails in arbitration is the party that would be entitled to prevailing party fees. Okay. All right. So that's it.
Yep.
Mm-hmm.
Tell you something that I got constantly when I was out on the field, when Kerstin was talking about taking amenities away from people who don't pay or don't follow stuff or don't pay, for example. The question that I would always get is, can we, if we have a bulk cable agreement, can we take away their TV access? And that's never a good idea. Even I don't need to be an attorney to say that, because that's where people get important news, things about pandemics or crisis situations. So that's something I wouldn't touch with a 10-foot pole.
Agree. All right, first question. If our ability to fine late payers has not been enforced for several years, can we start doing it now? Well, fining should not be used to fine those who haven't paid, right? Fining is really more for covenant violations other than payment of assessments. So just keep that in mind. Let's see here. There was a question here about self-help. Our docs allow for self-help to cure violation. What is the best way to cure violation that involves the homeowner's personal property? Case in point, homeowners are parking their cars in their yards to avoid being towed from the street. Also, they're storing construction equipment materials in their yards, front and side yards. So self-help, for those of you who are not familiar with the concept, it's a concept where if the owner doesn't do what they're supposed to, the board can basically go on the property in the unit, do what is required, and then oftentimes charge the owner for the cost of the association incurred. Self-help remedy has to be expressly authorized in your declaration. It's not something that's granted in the law. It's something that is derived from your documents. Having said that, there's currently there's currently case law in the state of Florida from different jurisdictions that is conflicting case law and will ultimately end up in the Supreme Court of Florida. But different districts have held different things about have held different rulings on self-help. More of the Southern District of Florida has held that if you have self-help remedy in your declaration, in the past, courts have said that if you have the self-help remedy, you are obligated to use that self-help remedy before you can pursue legal action against the owner to force the owner to comply. Okay. That is potentially problematic because, self-help remedy is not recommended in all instances, right? Like people are crazy. You don't want to show up at someone's house and start removing stuff from the property or start mowing their lawn or whatever else, right? Like it creates potential liability exposure for the association, damage. And not to mention, you can be confronted by a crazy owner, right? So self-help should really be used, on a case-by-case basis. And I would strongly encourage you to consult with legal counsel before you exercise self-help. Other parts of the state have held that, if you have self-help remedy in your documents, you don't necessarily have to exercise it. If you choose not to exercise it, you can go straight to court and force the owner to do what they're supposed to do, which is often the recommended approach. So rather than exercising self-help remedy, pursue the pre-suit mediation, pre-arbitration to compel the owner to do what they're supposed to. Okay. But again, this is one of those where you're going to have to, consult with your legal counsel for advice.
Man, there's one question here where I would recommend calling a pest control company. What is the process for abating a lawn that is knee-high and infested with snakes and rats? My answer to that would be, I'm moving.
Yeah. One thing, Kerstin, while you're looking through some of the questions, many of these on here are legal in nature, so I will allow you to answer them. But I did want to say something about practical application and enforcement. I think most boards and managers that are on will agree that the end goal for compliance and for establishing rules and regulations is compliance. You want the homeowners to follow what those covenants and rules are, and generally they have a purpose. So I think that practical application, all of the points that you made legally are important in how to enforce them if you're not achieving compliance. But there are some steps that we can take practically to get compliance without needing to utilize these tools sometimes. And I think one of those is communication with the homeowners across the board for the purpose of why you've established the rules, and periodically evaluating them to make sure that the rules that you have in place are going to achieve the purpose that you're trying to reach. And sometimes when you can gain that understanding and perspective with your owners, you will achieve compliance easier than having to go through some of these steps and use the enforcement tools that were granted legally.
Sure, absolutely. Let's see.
Christina, the slides are available after you fill the evaluation. The screen after that has a link to download the slides. Kerstin, go ahead. Sorry about that.
So does the board have to meet to impose a fine for current violators, or can they impose a chart of fines for violations? I mean, you can always have the board can adopt a resolution of, the amount of fines that you want to charge. Just remember, it can't exceed the $100 per violation, $1,000 in the aggregate, unless you're with an HOA, in which case you can if your documents allow. But you can't just adopt this resolution of fining schedule or chart and then just that's it. You still have to follow that two-step process. You have to formally adopt the fine against the violator, and then the committee still has to meet with that 14-day notice that has to be provided to the owner. So make sure you comply with that.
There is a running theme in some of the questions about violations that have not been enforced over a period of time, does that preclude boards from really ever enforcing them if they've been overlooked in the past? And I would say the answer is no. I mean, you don't have to forego enforcement forever. If a prior board or a prior management company did not consistently enforce them, you can still notify homeowners when they're not in compliance.
Yes, that is generally true. The problem can become if you then try to pursue the violation in court more formally. And that's where the waiver defenses and the selective enforcement defenses can arise, right? And these are viable defenses. So there is a process. If you, for example, haven't enforced a certain type of violation over a period of time, and you want to start enforcing it in the future, you're going to be forced to then go through a process called republication, in which you would essentially have to grandfather in existing violators so that you can sort of resurrect that restriction and then enforce it in the future without these defenses being raised constantly. So there is a process, and I would encourage you to then speak with your legal counsel about republishing correctly. Let's see here. Can a board member speak to a homeowner regarding a potential violation or violation that has been turned over to an association attorney? I mean, I would say once you've turned over the violation to legal counsel, have them handle it with the owner. That's the point why you've turned it over to counsel. Let's see.
Remember, folks, questions into the Q&A, the chat, or for the non-attorney related questions. That's for me, for the tech issues and things of that sort. We have time for just a couple more. I know Kerstin and Annette each have appointments they have to get to.
Let's see a couple more. Who levies the fine and who imposes the fine in condominiums? Yeah, fining is the way the statute currently has it. It's tricky, but essentially, the board has to adopt the fine. The board adopts the fine, and this is both for HOAs and condos. The board has a 48-hour board meeting at which it adopts a fine against the violator. But then remember, it cannot be imposed until the owner has been notified of a committee hearing, okay, at which the committee is going to hear the board and the owner, and then make the final determination on whether or not to impose the fine. That committee hearing has to be properly noticed 14 days in advance, right? And only if the committee affirms the fine can it then be imposed. So you got to do the two meetings for proper adoption and imposition of a fine.
And are fining committee meetings open to the ownership, Kerstin? If it's posted?
For condominiums, yes, they have to be duly noticed and open to the owners for condominiums. Let's see, maybe one or two. A lot of parking violations, but parking is tricky in the HOA world these days, so I'm gonna not answer anything about parking.
It sure is, yeah.
So a lot of questions of fining. I mean, I think I've kind of beat that one. And some complicated.
Thank you, Michael L. We'll let them know over in the chat. We'll say hi to everybody.
So someone raised the issue of Kaufman. Man, I shouldn't even open the door to that. But I think most practitioners would say that, fining, suspension of use rights is more of a procedural issue as opposed to a substantive issue. And so regardless of whether or not you have Kaufman language in your declaration, procedural changes to the statute will apply to your association, which is why if you don't have Kaufman, you could still fine because it's mostly procedural. All right. All right. That's it. I'm going to stop there or I will never stop.
Yeah, we'll be here all day with all the questions. A lot of great questions, but it's a hot topic.
Great questions.
Yeah.
Yeah, it is a hot topic.
But before we head out, I want each of you to please give any parting words, best way to contact you, and anything else you want to mention before you head out. And folks, remember, I will remain on for any of you still having technical issues for about 5 or 10 minutes. But ladies, any parting words? Annette?
Thank you all for attending. I'm glad that most of you found this valuable. It is a really hot topic. And thank you, Kerstin, for all of your insight and knowledge on this topic. If you do want to reach out to CopperDoor for any support or assistance, the best way to reach us is through our website, and we're at copperdoorco.com. You can always reach us at our direct number as well, which is 813-576-0606, or at the email address that Jeff provided in the contact materials. Thank you again.
Thank you, Annette. And Kerstin, always great to see you. When can we see you next? We have the Tampa Expo coming up, correct?
Yes, Tampa Expo in I think 2 weeks. So I will be there and I will be teaching 2 classes, the legal update, which mostly affects condominiums, and then I will also be teaching a class on HOA financial literacy. So it is only going to cover financials for HOAs under Chapter 720 of the Florida statute. So I do not specifically address anything on condos in that class. So
right, that class will get any of you HOA board members 2 credits, where today gets you the 1 credit. So that'll be a nice one to attend if you're in the Tampa area.
Thank you all for attending. And I can be reached my email, khenze@kbrlegal.com. And I believe our website has my email as well as our main office number, 954-928-0680.
Absolutely.
Thank you.
That's why she's the walking encyclopedia. Kerstin, have a wonderful day. Annette, nice to see you.
Have a great day.
Bye, everyone.
Both soon.
Bye-bye.